Let's see. Hello, everyone in Woodbridge. My name is Ken Vercammen, and I'm an attorney from Edison. Right down the street, Woodbridge Avenue is Main Street, and I went to high school up the street in North Edison, so I'm familiar with this area. And John McCormick was a year in front of me in high school, so he had better grades than me, but I could run faster than him. All right. A lot of times people ask me, Kenny, why do I need to have a will? Doesn't everything go to my wife if I don't? And he goes, yes and no. If you have children from a prior relationship, part goes to them. If there's no children, believe it or not, it doesn't all go to the spouse. That person's parents could get some. So remember, it's your idea to determine, hey, who do I want to get my stuff? And importantly, who do I don't want to get my stuff? There could be someone that says, well, okay, I'm not married or my spouse passed. Doesn't everything automatically go to my three kids? Yes, but you haven't selected someone to be the executor. So that means that all of them got to agree upon who's going to be the administrator of the estate. The others got to sign a renunciation from a notary and pay a fee to file that with the surrogate. And that's where everyone agrees. A lot of times there's the troublemaker goes, I'm not signing it, I want to be the administrator. How can you be the administrator? You live in Texas and you never ran. Well, so that means that the person who wants to be administrator has to go to court, spend, $3-4 grand getting appointed as the administrator and court fees, and it goes, well, certainly, will only cost about $500 each. Why would someone, if you really want to screw your family, don't do anything. By not doing any planning, it's like saying, I have a basement and this wood has been leaking off this pipe and there's a puddle on the floor. But I'm not going to do anything about that. I'm going to let my kids worry about that in 10 years. Now, if there's no will, the person who eventually becomes the administrator has to pay a fee to an insurance company, a bonding company, a couple more grand. And there's other expenses involved. But more importantly, when there's no planning, it often causes fights, aggravation, sometimes lawsuits amongst the family. And for people who have minor children, sometimes they go, listen, I don't own much. I would. But, we talk about, hey, if a meteor struck down both parents, who do you want to be the guardian of the children? Well, I'm not really sure. Okay, who don't you want? Because the family member that you don't want could go before the probate judge if there's no will and says, no, I want to have custody of the kids. I've been married 35 plus years, but I remember when we had our first kid and we were redoing the documents. It's kind of funny how when you're first sitting down, it goes, okay, who do you want to be the guardian? First, my wife goes, how about your brother Steve? My brother Steve, he's single, lives down in Belmar. He can't raise a kid. Oh, how about my mother? What? Your mother's insane. I mean, she's good to watch the baby for a couple hours, but otherwise, she'd be taking the kid to church 2-3 times a day, and the kid would be kooky like her. So, and remember, your will and other documents, that could be changed at any point in time. I mean, I'm an example. We first get married. Okay, we'll have my parents. And a lot of times, so we go, they're getting older. Well, everyone's getting older. Then my sister gets married. Okay, we'll have my sister. She's normal. But then my sister goes to Ohio and lives out in the sticks. Okay, I don't think my kids want to live in the sticks. So back to the parents. So the whole idea is when you do planning, you're making it as easy as possible for your family. No one would think about, if you were working and they said, okay, everyone's going to get a vacation on March 20th. You wouldn't wait until March 19th to say, okay, where am I going to go tomorrow? You do a little bit of planning. I've done, sometimes a surrogate has been a speaker with us, and they're the first ones to say, beware of doing stuff yourself online, because they see the problems they always see is where someone did it themselves, and it's either not signed right or not filled out correctly. So in a way, it's good to have a professional do it. When I was first married, I thought we bought a house and it's a wooden Cape Cod. I thought it was so smart because I could do the landlines on the phones. It goes, I'm going to redo the electrical work. And then I almost burned down the house. So, That was the last time I tried doing electrical work. So think about it. Okay, who's going to get your stuff? Yeah. When I was first starting out, because I got them in 1985, the old system was someone would sit across from me. Okay, Mr. Goshkagarian and Mrs. Goshkagarian, how do you spell your last name? Here's me scribbling on the legal paper. Then we at least had a form to fill out. But then I still couldn't read anyone's handwriting anyway. Especially when, the husband was Goshkagarian and the wife had a different name and their executor had a different last name. I couldn't read anyways. So now, we made it pretty easy. We email out a short questionnaire, and when someone says, I don't have kids, it's just 1 page long. I kind of called it the form I had to dumb down for some of my friends at the Elks Club, because they goes, Kenny, I'm not good with computers. I go, well, it asks you 4 questions really. What's your name? Who's executor 1? Who's executor 2? Who gets your stuff? After that, we can kind of go over a little bit more what you need, but it's not that complicated. Some of the seniors say, oh, I'm not good with computers. I goes, yeah, some people aren't, no problem. I go, I believe you said you're giving something to your adult grandchild. Yes, okay. You call that adult grandchild. She lives 2 towns over. Say, listen, I need you to come over for 45 minutes and help me with this thing on the computer. If any 45 minutes in the next 3 weeks. The granddaughter says, I'm too busy to see you or do anything. No problem. I was going to give you $1,000, but now I'll find someone else. You're out. Oh, no, never mind, Grandma. I'll come over. I'll help you out. Some people don't type. Some people are ill and they need the family to help. And I goes, okay, listen, but we still need to talk to that person. And it can't be, hello, Mrs. E, how you doing? I'm okay. Okay, tell me who you want as executive. Whoever my son wants. No, you got to tell me. It's kind of like prepping people. I had this DWI case, which I don't do a lot anymore, but the guy who kept on saying the wrong things the first time we were in court, and I go, sir, when the question is a yes or no, it's yes or no, not a story. So we got to sometimes prep the people. Okay, an executive 1, an executive 2. Some people goes, well, I'd like to have my kids as joint executive. He goes, that's dumb. Why? He goes, that means that both of them got to do everything together. 2 people got to go to the surrogate's office. 2 people got to sign every check. 2 people got to go to the real estate clause and do everything. It's better to have a number 1 and a number 2. There's only one. Bill, I like to them have to share the duties. Listen, there's one president of the United States and there's a vice president. They don't share the duties. Now, and by the way, some people do updates in their wills because the person they might have originally had as their executor can no longer do the job. Our rule of thumb on the executors: can they drive to the bank and can they walk up a flight of steps? If they can't, then, well, is there someone else that can do it? It's not that we're, anti-senior citizen. We're realistic. So, no assets typically get listed in the will. Most people goes, everything's going to this person, and this person passes this, who gets their share. People always say, why aren't any of my assets listed? I goes, I'll be able to list you as long you need to type up the day you're going to die and when you own that day, and we can put it in there. They goes, I don't know that. That's always good. But the other thing is, you don't know what you're going to have on your last day. Remember, a will is a public record, and most people don't want other people to know their business anyway. I'd say, yeah. So the will, most will say, who gets your stuff? Now, your will says who gets your stuff, but certain assets, and Brandon kind of touched on this a little, don't pass under the will. Because if you have beneficiaries on accounts, those people get it. The will can't change who you have as beneficiaries. And that is kind of important because some people, as they go along, they say, listen, I would rather have certain assets go to X than the other ones. And easy enough example is Mr. M contacts us one time. He goes, listen, I want to get a new, I'm sick, I want to get a new will done. Originally I had everything going to my adult grandkids, but I haven't seen or heard, they live the next town over, they don't have anything to do with me, they haven't called me. And he goes, I don't, why should I reward them? Okay, do a new will, they're out, but he never changed who's the beneficiaries on his retirements. So the will does not override that. So, the expression is sometimes the bums get stuff because it was never changed. A house that's owned husband and wife, if someone passes, survivor automatically gets it because it passes by title. People often say, I need to do a new deed because my deceased spouse is on it. I just say, no you don't, I just saved you $800. Other assets pass, like, for example, if a bank account is payable upon death or joint, automatically goes to the survivor, IRAs, etc. Now, some people have, if they have minor children, I say, listen, take your minor children's names off as beneficiaries and just put the magic words, my estate. Person goes, what does that mean? Well, right now you're having it go to your spouse and then to my estate. This way, otherwise, if it's your minor kids or grandkids, they get the money the day they turn 18 with no supervision. How many 18, 19-year-olds would ever do smart things with money? Pretty much zero. Boy, if I would have got money when I was 19, I would have went to Maloof and goes, hey, you got any $100,000 sports cars? I got $100,000 with me. And then the salesperson goes, wow, you're in luck. We happen to just have one left. But someone else is about to bid on it. You better go bid on it right away. So the idea is, look to see who's getting your stuff. And again, it is your right to do with your stuff what you want. A client last year says, I got 4 kids, but do I have to treat all my kids equally? Because one of them, I don't hear from much. He lives on the West Coast. Okay, let me ask you a question. Did he send you a card or a call on Christmas, Mother's Day, or your birthday? No, we don't hear from him much. I go, why would you leave anything to that bum? Don't leave him $1. Don't put any reasons. He knows the reason. And he goes, listen, if he's getting money, that's the kind of person that the day you pass, 15 minutes later, that kind of person is going to be, where's my money? I want my money right now. So, simple line, nothing to X. Not $1, nothing to them. Easy enough. So, some people have what's called specific bequests. They might say, listen, I have jewelry. I want to give it to my daughter, my granddaughter, because my son's the executor. He's going to go to cash for gold. He goes, what do you give me for this junk? Some people want to have certain things go within the family to certain people. Some people say, listen, I want to have certain amounts going to a charity, a church, etc. I'm in favor of supporting charities, but sometimes it's better to put a set amount, because if you leave a percentage to them, then everything has to be, there needs to be a formal accounting approved by the Attorney General's office. They take months and months and months and months. So we're helping out in a state where the guy thought it was nice, 1% to this charity, 1% to that charity. And the executive goes, they're getting $9,000 a piece. It's going to cost us $9,000 in accountant fees to do this formal accounting thing the Attorney General wants. So when someone says charity, says, listen, tell me what you really want. So again, remember, the only thing you can't leave a spouse penniless. Other than that, you want to leave everything to the Dog Society or your high school, whatever. That is your right. And we've already talked about, I call it the reverse specific bequest. Nothing to X. No reasons. if you already have a will, take out the original and look to see, does it still have what you want? And can the executor still do the job? And I also say the magic word, the original, because only the original will can be admitted to probate. That was the law 100 years ago, and that's the law today. Some people goes, I can't find the original. Okay, listen, if you can't find it in the next week, get a new one done. Because if you can't find it, someone else isn't going to find it. I'd say, years ago, my wife was looking for our kids' birth certificates because we were going to Canada. All you needed was a birth certificate. Well, her filing system was the cardboard box. And when it filled up, there was a new box. There's a whole bunch of boxes. Then she got more organized. There was like 50 different files. No organization. They were just thrown in the cardboard box. It was easier for me, because both my kids were born at St. Peter's, to drive to the New Brunswick, health department and get a new birth certificate. It goes, listen, we ain't ever gonna find these. Let's see, Canada's gonna be back part of England again by the time we find this stuff. Okay. Randy, now, let me touch upon trust before I finish up with the will thing. I'd say,
quick question.
Right. Yes, sir.
Every will has to be probated, correct?
No.
No?
Because, okay, if a meteor strikes me down tomorrow, my house is owned jointly with my wife. All our accounts are either joint or payable upon death to her. I'd say the only thing that is not joint is the car, which then there's the surrogate has for small estates, the short form. So it's very common where, say, I need to come in, like my spouse passed. Other than that, the will has to be admitted to probate if you own stuff. Now, sometimes someone doesn't have anything by the last day. Let's see, Larry from the Three Stooges, the one that had his hair sticking up kind of on the side. He lived in the hotels his whole life and lived big, and he died with almost no money. Good for him. From Star Trek, the original, Dr. McCoy, say he lived big. Let's see, hey, that's how you want to go. What, you want to have the best gold-plated casket in the whole cemetery? I saw in Neptune Township, there was this giant monument that, someone had to them. I guess in the olden days, people would go and, visit the family plot. No one's going to go visit me when I'm gone. Let's see. Except, the mom and bar, someone had donated money to say once a year they were going to have like a drink on this guy. And I go, well, that's a pretty good idea. I like to do that. My wife torpedoed that, but she goes, I want the money. But let me kind of touch upon revocable trust for a second. Let's see. My mother-in-law used to call me up every other year. She's still around. She's going to be 93 years old December 1. I want to come in and get a trust done. Revocable trust. And I goes, we were watching Susie Orman on TV. She says, oh yes. Because Susie Orman is exactly right. In New York, California, Florida, where the probate process takes 3 years, it costs $15,000. New Jersey probate, all the surrogate needs is the original will, the death certificate, form filled out, a check for $190. So whenever someone says, I want to have a trust to avoid probate, I ask, why do you think you need to avoid probate? And it can be because your friend who lives in Florida or wherever has one. Because there are trust salesmen that are selling trusts. They were giving people like dinners at some restaurant and trying to sell people the $5,000, $6,000 revocable trust package with the fancy looking book. And I read a book about doing that. And it was called Building the $1 Million Estate Planning Practice. And I goes, you know what? Would I feel right trying to trick my best man's mother into getting one of these that she doesn't really need? No. Let's say, when I was a kid, and the Sisters of Mercy were smacking all of us in the head, trying to teach us, good manners. It was also about trying to do the right thing. And I asked people, why do you think you need to have a trust? Every once in a while, someone goes, Kenny, this is what I want. And, okay, fine. Okay, but yeah. So, and I'll come a little bit more to that later on. Now, self-proving will. There were some changes in how wills were done in New Jersey. There used to be a problem because the law some years ago said the person signs and two witnesses, but then one of the two witnesses would have to go to the surrogate's office and sign an affidavit saying they were the witness, in front of a notary. Well, sometimes you couldn't find the person.
Could be dead.
They're dead. Or when my grandma passed, it was done the old way. When you locate one of the witnesses, work for the law office, she goes, "Yeah, I'll sign the affidavit. My fee's $500. $500." My dad goes, "We're not paying you $500." But he goes, "Okay, go get the other witness." Well, they're dead. Now we could have said, "Screw you, lady," but then we would have had to spend $3,000 filing a complaint order to show cause in front of a superior court judge. So this is changing this law that provides for what is a self-proving will. So you don't have to find witnesses, but the person signs, there's two witnesses, then the attorney or notary signs, person signs a second time, the two witnesses sign again, the attorney or notary signs again. So if you already have a will, make sure it's a self-proving will. I knew an office that used to be in Carteret, and even after the law changed, they were potentially not doing self-proving wills. So that hoping that the people would come back to them and say, I need one of you people to witness the will. And I remember talking to the attorney. He goes, "Hey, you guys are good, not doing it right. Oh, if someone really wants a self-proving will," he goes, "we'll do it." He goes, "No one in Carteret knows what a self-proving will is." I go, 50% of the attorneys in the state of New Jersey don't know what a self-proving will is because that's not what they do. So you want to have a self-proving will, and now, only the original will I mentioned can be made to probate. You want to, it's still okay to scan it and email it to yourself, and email it or make a copy and let other people know where the original is at. Let's see. But you just get a fireproof box from Costco, throw it under the bed where it collects dust until the day. Don't put it in a safe deposit box. The problem is you can't get to it. And especially sometimes it's not just the will, it's the power of attorney or the living will. And let's see. And the problem also with banks are never usually your good friends. My dad one time, he says, "Hey, I put you on the safe deposit box and your kids' bonds are there." And I goes, "Okay." And one day he goes, "I've never been to a safe deposit box. They see them on TV. That's where the pizza shop guys hide all their cash or their diamonds." So I go to the bank with the key, with my ID. But by that time, the bank, First Fidelity got taken over by Countrywide and then by Wells Fargo. Wells Fargo took bad record. "Oh, you're not on this safe deposit box." Now here's me. Bullshit. Listen, if my father, the engineer, said that he came to this bank and filled out papers, I know he did. I mean, he's not an old guy getting lost driving a ShopRite, but the banks didn't have good records. Let's see. At least my mom was still around, and she was able to drive up from Jackson. And then after she signs the papers, they tell me I can go now. And then the Wells Fargo people are trying to sell a 70-plus-year-old lady a 30-year annuity. So have it where people can get to it. Also, hey, what happened in March of 2020? The world closed. Hi, bank. I need to come over and get it's very important. I need to get the living will. I'm going for surgery. We're closed this month. Come back when the world reopens. But I need it now. Well, good luck. Fireproof box. I mentioned, okay, Revocable trust, I love making money. I'm a business person. But I tell people you don't need to set up this fancy revocable trust for most people. And someone just today when I was driving around, she asked me she wanted to have a revocable trust. I goes, I already prepared one for you in a way. I go, you got minor children, so it says everything's going to your spouse, it goes to your kids, but your kids don't get the money outright because they'll have the best party ever. Instead, they get some money when they're 22, some when they're 25, the balance when they're 30. But the trustee, who you pick from your family, can spend as much money as is needed for health, education, grad school, etc. And if they want advance money, if they deem appropriate, that's cool. So, someone finishes college and says, listen, I need money for grad school. Okay, that's good. They goes, listen, I graduated college and I got a good job in this other state. I'd like to buy a condo there. Okay, that makes sense. On the other hand, 20-year-old goes, college is very stressful and I need to take some time off and I need to go on a trip across Europe with 10 of my friends and I need $100,000 because it's very expensive. And trustee goes, you better work more hours at your crummy job after you dropped out of college because I don't think your parents worked really hard so you could goof off. So that's the testamentary trust within the will. Some people do testamentary trust within the will. This way you don't have to fund it right away. It's only until you die. You don't have to deal with getting tax ID numbers. Sometimes you got the person that is a grown person, but they shouldn't get money. They're a spendthrift. They could have an alcohol problem, a drug problem. We helped out in a state where the mom was smart to say, listen, everything. I got 4 kids, it's split 4 ways, but the money for the oldest son is going to be held in a testamentary trust for his support, and that way one of the sisters was the trustee, and she paid his rent, she paid his car insurance, and she would give him periodically ShopRite gift cards to go and buy food because if she gave him regular gift cards, he would have bought booze. So the guy's ex-wife files a complaint in the Superior Court saying, I'm owed alimony. Judge, I want you to order him out of this trust money to pay the alimony I'm owed. And I said, Judge, the whole reason for setting up this testamentary trust within the will is so that it's protected from error. It's one of few that it's protected from taxes that are owed, it's protected from Medicaid. But this way you don't have to set up the trust right away. Those are a couple ideas. Brandon already talked about irrevocable trust, and people worry about nursing homes. The attorneys that do it usually charge $13-15 grand up front. If you say I don't want to spend that much money, you're probably not going to find someone. Okay. If you don't already have a will, get one done. Don't be a Carl. What's a Carl? Who's Carl? So, Carl was this retired engineer, and nowadays people email me the short type form, and I have this new thing called the telephone where I pick them up and talk to them, he goes, and I go, this is what I would recommend, boom, 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 and then back then there was an estate tax. Well, I'd like to read more up on this. Carl, you don't need to read anything. I already read for you. Say, listen, Carl, when I had knee surgery, I didn't read the book on how to do knee surgery. I asked the doctor, hey doctor, have you done this before? The doctor goes, I'm the team doctor for Rutgers. I do 3 a day. Okay, good. That's all I need to know. Well, anyway, Carl goes, I want to, these engineers they were the kind of guys that when they got a new car, they would read the whole book. And then that came with the car. And the computers used to have a book that was this big when, paper, and they would read, So, okay, fine. So 2 years later, Carl's daughter calls me. My dad passed, you have his will, because I found your papers and I found your will brochure with his stuff. I goes, no, Carl wanted to read more up on it. So he screwed his family because it ended up costing him more money because they had to go through this lengthy administration thing. So you don't need to read anything. Oh, by the way, anyone that is nice enough to come to one of our seminars, I do a free consult. Most attorneys, we usually charge something if someone just wants a consult. But going back to, we emailed a will questionnaire, and this man types it up, and he's like, I'd like to come down and sit with you. I goes, Mr. Shah, I know you're married. Are you disowning your wife? No. He goes, you want everything to go to her, right? Yeah. Okay, Mr. Shah, I know you got 3 adult kids. Are you disowning any of them or treating them unequally? No, I want it in equal share. He goes, listen, I know what you need. I'll save you a trip. The old system of, hey, you working people, you got to take half a day off of work just to come and sit down with me so you can write stuff down. Now, the will still needs to be signed in front of 2 witnesses, 2 human beings over 18, and the attorney or notary. You can't do it remote or by Zoom or stuff like that. And some of the people who work for big companies have what's called legal insurance, where it pays for the will. Some of the big companies that the corporations have is MetLife, Hyatt, they pay for. Some people have kids that are special needs. Then in that instance, sometimes they set up what's called a special needs trust, but it has to comply with certain state and federal laws if they're handicapped kids. All right, that's all you need to know, really, about wills and trusts. I'd say, let's talk briefly about power of attorney, because I forgot I was supposed to be out of here at 7:30. They turned the lights off, but. The will takes care of your assets if you pass away. What the power of attorney is while you're alive. You're giving the power to somebody you trust to be able to pay your bills and help you out legally. You're not giving up your rights. You're not declaring yourself incompetent, but you're saying, listen, I'm giving the rights to this person. And does it have to be the spouse? No. I mean, it really depends. Can your spouse do the job? Sometimes it's not the spouse because they say, listen, my spouse, English is not their first language, or my spouse itself has medical problems. Sometimes we do wills where someone goes, listen, I love my spouse so much. I'd say, and if there was a magic pill that would make my spouse well, but I had to cut off all, 5 of my fingers, I say, okay, let's do it. Sometimes it goes, we'll say, listen, I don't leave anything in the will to my spouse because they wouldn't be able to enjoy it, and the money would probably have to go towards nursing home down the road. So same thing with the power of attorney. Sometimes you don't want to have the spouse. Now with the power of attorney, you'll have a number 1, like the executive 1, and number 2. The power of attorney is either effective right away or only upon disability. When it's effective right away, it's called a durable power of attorney. It stays effective even if you become disabled. The one effective only upon disability is called a springy power of attorney. And that way it only springs into effect if you become disabled pursuant to the New Jersey statute. Let's see. One of our clients, Freddie, goes, Kenny, I'm a carpenter. I don't understand this legal stuff. Explain to me in carpenter language. I'm good with wood. Okay. If it's effective right away, you picked your son as your agent, your son can steal all your money right away and go to Cuba. If it's effective only upon disability, he has to get a note from a doctor before he steals all your money and goes to Cuba. Knowing that, you trust your son. He goes, I trust my son with my life. They make it effective right away. And I only mention Cuba because they don't have extradition with the United States. It's Bahamas or some of the nice places. They'll find you and bring you back, because that's stealing. Someone goes, how can I be sure that my executor will do the right thing? He goes, well, there's laws against stealing. If they're stealing the money, they can be prosecuted. You know, yeah. A will is good forever. Sometimes you want to update it. There's no statute, though, in New Jersey that sets forth how long a power of attorney is good for. So our rule of thumb, it's a good idea to sign a new one every 5 years. Because if someone goes to Brady's company, the good people at Merrill, and the power of attorney is 13 years old, they're going to say, well, how do we know that there wasn't a new one done? Or et cetera, et cetera. So that's kind of, and plus when you're redoing it. Now, and this is an example of why, so you also with those, don't rely upon some cheap thing you find online. A lot of the banks were not honoring perfectly good powers of attorney. First union. Oh, it wasn't done in our standard first union form, so you got to get the person to say, well, it's too late. Well, I don't know. So New Jersey legislature came down with a statute that said, listen, if it's mentioned in the power of attorney, the statute itself, then the bank doing business in New Jersey got to honor it. But it has to make reference to Section 2 of PL 1991, C95, C46:2B-11, and I'm pretty sure those cheap things or free things you find online are not going to have that. If you don't have a power of attorney, get one done. If you have parents or family members that don't have a power of attorney, encourage them to get it done. I mean, the expression, you can lead the horse to water, but you can't make it drink. You can encourage people to do stuff. You hope that they do the smarts. We get a call every week. Oh, I need to get power of attorney over mom, dad, my brother, etc. And I go, okay, can they talk to us over the phone and tell us what they want before you type it up? No, they're at Roosevelt Hospital or they don't know about this. He goes, someone can't get power of attorney over someone else. That person, the only thing you can do is if the person is that bad along, if they never sign one, you'd have to go through an expensive court guardianship proceeding, and that where you're asking the court to declare the person incapacitated. The word used to be incompetent, but that was an ugly word. But it's really the same thing. Yes, ma'am, in the back, and Guy.
Question. You retire, you got your will drawn up here in New Jersey.
Yeah.
You're going to go find the Fountain Youth in Florida. Your power of attorney's up here in New York or New Jersey.
Right.
Do you have to alter that power of attorney to reflect that?
So the question is, well, let me talk to you about the will first, okay? A will that is done in New Jersey is valid in every state in the United States of America, okay? However, your power of attorney that is done here may not be recognized by a bank in New Jersey because they don't know what PL 1994 is. So my rule of thumb with people is if they're moving out of state, after they unpack, make an appointment with a professional in their state to say, hey, listen, I did these documents in New Jersey, but what would you recommend for me now? And you mentioned the word Florida. Now, Florida is one of the worst probate states. And my father-in-law was a World War II vet, and he was living in Florida. He had a condo. And 15 different times we say to him, JB, you should put the condo in Florida into a trust. It's a lot. Oh, nobody tells me what to do. Ukrainian World War II vet, he's from the U.S., but nobody tells me what to do. And I remember, my wife was flying down to go visit him, when it was close at the end. He goes, I'm going to talk to my dad about the trust. And he goes, don't aggravate yourself. And him, he ain't going to do it. He's, and a lot of times, part of doing planning is, we won't do something if it smells. If someone says, mom or dad wants to do a new will, okay, we'll need to talk to them. Well, that's a problem there or wherever. And so, okay, but they want to leave everything to me. How many kids are there? 3. I don't know, that pretty much smells. fellow one time we're doing his will, and he goes, "Oh, we also need to do a will for my dad, but his English, he's very, very poor." I'd say, "What does he speak?" "He speaks Gujarati." "Okay. How many kids are there?" "3. "Is everyone being treated equally?" "No, he wants everything to go to me." "Okay. You got to go to an attorney that can speak Gujarati." He goes, "But I can translate for him." He goes, "Yeah. I could say, 'Sir, do you want him to get everything?' And your translation is, 'Dad, I'm going to buy you lunch today. Is that a good idea?'" So, and that's what in Surrogate also says. A lot of times when the problems they see is when someone when someone's really sick and they never did anything, goes, "Oh, just sign here, Grandpa, so we can help you out." Yeah, it's a new will. So, okay. Let me I went past my time, but let me briefly talk about the Living Will Advance Directive. And by the way, I got a brochure on power of attorney in the back and one on living wills. So, the Living Will Advance Directive, that's the document where you think of your future, you're in a coma, some type of irreversible medical condition. You can no longer talk. As long as you can talk, you're the captain of the ship. If you're 100 years old, the doctor goes, I don't think that we should continue all this stuff. And a 100-year-old person goes, "Nope, I want keep it going." "Oh, okay, you're the captain of the ship." Your power of attorney doesn't overrule that. So this is why you're giving instructions to hospitals and doctors, kind of what you would want, I'd say, and it's really what you don't want. And it's an important document because it's not really for you. It's for your family so that they don't have to be put in the position where there's no living will. The doctor says, "Okay, should we remove life support today?" "Geez, doctor, I feel bad. I know what the right decision is for someone who's 92 years old, but you hate to be the one to the doctor to say, 'Yeah, do it, let's, okay, go into it.'" You feel bad. This way, instead, you have the living will, and the doctor goes, "Okay, what should we do?" Hey, back in 2024, first to the living will, they said, "I don't want to have fluids and nutrition. If there's no hope for me, I don't want to have respirators and all these artificial machines. If I'm never going to walk the planet again, open up my eyes." And by the way, New Jersey, just a year or so ago, they adopted the Death with Dignity Act. And, it's where if someone has been diagnosed with the type of, horrible medical disease that they're not going for, it's less than 6 months. You got Lou Gehrig's disease or whatever. The person can affirmatively say, "Okay, I want to administer the meds to myself to end it all." So that's a couple of things to think about. Kind of the most important things, though, is that if you haven't done your documents, get them done. Don't be a putter off like Carl. Don't say, "Yeah, I'm going to get it done, but it's Thanksgiving. I'll do it after Thanksgiving." But then it's Christmas. I'm going to do it after Christmas. Let's see. And then, for the seniors, they're kind of they wait till the groundhog comes out because they don't want to leave the house because it might snow. The sky's great. I better not go out. It might snow. So I've never had anyone in the 35, 40 years I've been doing this where they said afterwards, "I wish I didn't do that." Everyone's like, "Well, I'm glad I got that done. I've been putting it off for so long," and they go, "Kenny, you made it easy." People goes, "Oh, I'm getting around to. I'm getting a list of my assets together." He goes, "I need to know what your assets are." I goes, "Well," I said, "is it more or less than $13 million?" They look at me. He goes, Less? Okay, well, because 13 million is the magic amount for federal state taxes. But if it's under that, I don't need to know. I do ask, where's your real estate? Because if they have real estate in another state, we go, we discuss, because in those other states, there's a thing called ancillary probate. So everyone has a condo in Florida should run out and have it owned by a revocable trust, because Florida and New York are nightmares, but New Jersey is super easy. So thank you, everyone. Take brochures in the back, and Brandon and I are going to hang out for 9 minutes and 50 seconds to answer questions, but you can come up here while everyone else is going out. All right, thanks.